Now we get to one of the most critical turning points, the recant. The defense presents the complainant's new statement, claiming she made up the accusations under pressure from her family. But here's the thing, recants in domestic cases are extremely common. Judges know this. Prosecutors know this. Why? Because victims often reconcile, feel guilty, fear losing financial support, or face pressure from family. The judge even says it directly, people recant all the time. Recants do not automatically destroy a case. In fact, prosecutors can still go forward if there's body cam footage, witness statements, physical signs of struggle, or even just consistent officer testimony. Here's the big question for you watching. Do you think recanting should automatically nullify an assault case, or should the system press on to uncover the truth?
And now you've picked up 2 more assaults of a family member. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
One of the complainants and the defendant are married. On November 2nd of 2024, officers were dispatched to an assault at a residential home in Harris County, Texas. Officers met with the complainant, who stated that she and the defendant have been common law spouses for 9 years, and that complainant and defendant were at complainant's father's house having a party. The complainant went to move their car so a guest could leave. The defendant became agitated and left. The complainant caught up with him, and he was laying down on the ground. The defendant grabbed the complainant's hair and struck her with an open palm to the face. The defendant stated, "There's no mark, so there's no proof I hit you." The complainant stated she felt pain. Complainant 2 is the brother of complainant 1 and is 16 years old. Complainant 2 stated he saw the defendant cause the scene because of the vehicle being moved and observed the defendant cursing and screaming at complainant 1.
As we approach the end of this hearing, the judge makes her position unmistakably clear: public safety comes first. With multiple accusations, a violated protective order, and escalating behavior, she refuses to grant a PR bond and instead enforces strict conditions: GPS monitoring, no alcohol, 200-foot distance restrictions, and a strong warning that any violation will result in an immediate, harsh bond reaction. This case shows how seriously courts take repeat family violence allegations, even when complainants recant. Whether these charges hold or fall apart at trial will depend on evidence like body cam footage, photos, and witness reliability. But for now, the judge is locking down precautions to protect the alleged victims and the community.
Cursing and screaming at complainant 1. Complainant 2 heard screaming and went back outside. The complainant 2 saw his dad holding the defendant by the wrist while on the ground. The defendant's parents.
So the son sees him holding the wife down. Is that what you're saying?
No, Judge. I'm saying that, so the brother, complainant 1's brother, saw his...
Complainant 1 being the wife.
Yes, complainant 1 is wife, Judge.
Brother.
So complainant 2 saw his dad holding the defendant by the wrist while on the ground. Defendant's parents are called, and the defendant was let go. The defendant began to yell and scream at complainant 2 again, and then lunged at complainant 2's dad. Complainant 2 got in between them, and the defendant struck complainant 2 with a closed fist to the side of his cheek. Complainant 2 struck the defendant once back. Officer stated a reasonable person would feel pain after being struck in the face, so he struck complainant 1 with an open palm and complainant 2.
Now, the complainant in the first assault, who is that?
Judge, it's Christian Martinez. So there are 2 complainants in the other assault.
This is my wife, Your Honor, Stephanie Martinez.
Do we need your help? You're in enough hot water as it is, Mr. Mancias.
I understand, sir.
So it was the wife, Judge. So there are 2.
So she gets another round, right?
Yes.
A new case is against the same complaining witness.
And there are 3 open AFMs now in total.
Welcome back to the channel, everyone. Today's case is one of the most chaotic domestic situations we've seen in this courtroom series. We've got multiple assault allegations, a fast recant, protective orders, and a judge who is not playing around. The defendant is facing not 1, not 2, but potentially 3 active assault cases involving the same complainant. And just wait, because the story gets messy fast. family witnesses, conflicting accounts, alleged retaliation, and a judge ready to go nuts on bond conditions. Buckle in, because this one turns volatile within minutes.
What is the one thing I asked you not to do?
I understand, Your Honor.
Was there no protective order at the time?
There was a protective order, Judge. They said that they were having a celebration at the dad's house. So I would imagine, but I can't say.
This was initially sent to the ERD, so I want to keep it again. We're going to keep it. Okay. Mr. Macias, I'm going to find that you are a complete and utter danger to my society. And there's only one thing that we do. Guess what happens now? I'm entering now magistrate orders for protection on both of those people. And I'm ordering you not to have any contact with either of these people. You violate these conditions, I will have a hearing as to whether I'm going to hold you at no bond.
Yes, Your Honor.
Do you understand?
I understand, sir.
I'm also now going to put a GPS monitor on you so I know where you are at all times. And I'm ordering you not to consume alcohol or illegal drugs.
Understood, sir.
You understand?
Yes, sir.
Any more issues, I'm going to make your bond so high you'll have teeth falling out.
Yes, Your Honor.
Goes with you.
May I make one statement before?
No.
Stephen sign.
Jesus Macias, Your Honor, this was the one that was up here a little earlier.
Is it, you said?
Macias, he's the one that picked up, I just got to point it on the day.
Oh, yeah.
Yeah,
Okay.
the
two new assaults.
two new assaults.
Yes.
Okay. All right. So I talked to Mr. Macias for a while, and he was going to share with you a few things that would kind of help give some more context in the case. On his two known law violations, there was a rip call that was made to his the complainant, and the complainant basically said kind of what verbatim what Mr. Macias told me, that he was actually attacked by her family. He called 911. When he called 911, she became very upset, made up the story of the assault, never saw the brother be assaulted. So you have, on the two new assaults, you have brother on one, and then you have wife on the other. So she basically recants and says that the assault on her never happened, and she says that she doesn't witness anything as far as with the brother. Okay, those are the two new law violations. She also makes a reference to the first assault, which he's currently in the court as well, and said that that was made up as well. Now we have people that recant all the time, but it would be.
I mean, I'm not going to take his word for it just because it's right.
Well, no, of course, Judge, but it should be noted as far as on this recantment as well that
This
she
is our
actually.
first major turning point. At this timestamp, the officer's report describes a very clear sequence. The defendant allegedly becomes agitated over something as small as a car being moved, walks away, and the complainant follows, only to be struck in the face. What's key here is the defendant's statement: there's no mark, so there's no proof. For viewers, remember this: physical injury is not required for an assault charge in many states. Pain alone, witnessed behavior, or corroborating testimony can establish probable cause. So when he claims no proof, legally that's not how the system works. Let me ask you, do you think the absence of visible marks should determine guilt? Comment below.
As well, that she actually asked the state, does she need representation for the false report? So that's a little bit different. That's usually, you don't usually have it to where people are concerned about getting representation for making a false report. That's usually a little bit extreme, so to speak. She's actually asking for it to be
He's
dismissed.
on bond for an assault against this person, picks up another assault, right? And then another assault against another person. I'm putting an order for protection in, and I don't want you to have contact with this person. I'm still going to take you in. I mean, I have something that's said here. People recant all the time after the fact because for whatever reason, but I have something here. I think that there's enough evidence to go forward. And I think that I believe that probable cause did occur. I'm not going to take your word as gospel. I don't know. Maybe the facts will show something different later on, but the evidence is going to point to whose side is correct. I don't know. Perhaps there'll be photographs. Perhaps there'll be body cam footage of what a person looked like. I don't know. But this is stuff that we got to wait for to see what happens. But
Your Honor, we're also approaching on bail, being that we do have a recantment, and the recantment was pretty quick. And the complainant is also asking for a dismissal. We're gonna ask for a PR bond on, this is the thing, I would definitely argue that there's gonna be, I mean, at the very least then, if that's the case, then I would like a speedy trial. Because if we're gonna, if.
Yes, and I'd be happy to give that to
I
you.
would rather do that.
And I absolutely love your tenacity.
Oh, I want it,
I love your tenacity, but on the PR bond,
understandable.
I
Well, we know that you wanted to set a bond, Judge, so we'll.
did. I said it at 15,002. Because I want you to understand that we mean business. And my utmost important is public safety. And that's the only thing that matters to me. Do you understand? And if I find that you have contact with this person and I don't care what is going on, so help me. Do you understand?
I understand, Your Honor.
Judge, that was 15,002 on the old case.
Yeah.
And on the new cases, those are going to stay at
Leave it as
1,000.
is. I'm going to leave it as is. I'm not going to touch it what the magistrate did, but I'm just going to revoke the old one because he picked up the two new cases. I'll leave as is. Within my right to revoke it and raise it and make it higher because I think that you're an utter danger to the public, right? I'm not going to, but understand that we can. And if I find that you violate any of these conditions, I will go nuts on the bond. Do you understand?
Understood, Your Honor.
Okay. We've given you a lawyer. It's your responsibility to stay in touch with him. When you get out, you will have an ankle monitor, so I know where you are at all times. You're not to go within 200 feet of where she lives, or he lives, or where they work. You understand?
I understand.
We will see where it pings at all times. So if you go anywhere near these people, get ready. I will give you the speedy trial. I need to give them at least enough time to get their evidence, to get their motions and subpoenas in line, which is at least 30 days.
And
After that,
I don't press the state. I've worked for the state before, so
yeah.
I can be
So
amenable to a time that works for them. I just want to be fair to him as well.
I mean, it would be probably in January, but whatever date then, we're gold, whatever you want. Yeah, of course. All
This
right.
moment right here is where the entire courtroom tries to untangle who saw what, and it becomes a puzzle of family members reacting at the same time. The judge is clearly confused, and honestly, so would most viewers. The key issue is credibility. Who was the primary witness, who intervened, and what actions actually took place? When cases involve multiple relatives, especially in the heat of a family gathering, stories often become tangled fast. And judges know this. They've seen countless cases where family members either exaggerate or minimize events to protect someone. Here's the real question: in a situation like this, whose account would you trust more, the complainant, the juvenile witness, or the officers on scene? Let me know what you think.